Video. Può iniziare?
Buongiorno a tutti, vi dico questo buongiorno in italiano, in 2 secondi cambio la versione, soprattutto volevo ringraziare tutti chi sono venuti qui per impegno, per dedicazione, per diciamo interesse nel questo tema che finalmente è tema che possiamo affrontare da tutti i punti di vista, tema politico, economico, sociale, e che per l'Italia è soprattutto molto interessante. Now I'm just changing the language. So good morning, everybody. Thank you very much for coming. Thank you very much for your dedication, for your efforts to be here. First of all, I thank all speakers for preparing, for looking at this and analyzing these themes related to undocumented migrants. I thank enormously my students who massively participate in this event. So with their presentation, with their little arguments and fresh ideas. So I'm really grateful to my students and those who don't participate actively for being here, for listening and being interested in the topics that we are considering. So this is the start of the conference. Conference is on undocumented migrants. I had a little problem with the title, so I invented this title, The Quest for Rights, Better Legal Protection and Security. I hope that we satisfy the requirements of Professor Naak, who doesn't like the concentration on the rights and the legal issues. So we're very happy because we are very happy to accommodate the issues maybe in the word security. So what I wanted to say that the conference is absolutely interdisciplinary. We have different speakers, with different backgrounds. They do different things in life, but exactly to put this all together and to look at the problem of undocumented migrants in a holistic way, because we cannot look only the law, because the law would make the issue separated from other situations, social and other contexts. So I just wanted to go through very quickly who we have in the morning, to whom I'm extremely grateful. So we have first Professor Martin Jones from the University of York. He has been researching in the area of migration probably all his life. Maybe he would say no, but well, I don't know. And he has enormous experience all over the world. Now they've heard in Africa dealing with migrants. So I think that his experience is extremely important for us. We also have Professor Naak, who is her background is in sociology. She's also extremely dynamic, runs all over and deals with security and how to defend migrants. So she knows enormously. She is just really a specialist in the topic. We also have, and I'm so grateful because I always tell him too late and so on. So we have also a director of the Center for the Refugee from Pavia, Dr. Luigi Vanella, who will tell us something about the law Cutro. As you know, we had disaster in Cutro, which should be mentioned, and maybe I will mention in 5 seconds very briefly about this. And we have the law culture, which many say has nothing really to do with the disaster in culture. So it's very strange, this connotation, because finally the response to the cultural disaster should be completely different than the law of culture. So then we have our own our colleague from the University of Pavia, who was a leading person for the project of migrating. She was teaching on gender and migration and so on. Professor Emanuela Dalzotto, some about the law, in security irregularity. And then we have Professor Ricci, who is just teaching at the moment. Has a very interesting opposite claim about undocumented migrants. So she would finish the session. Then we have a reception. So I'm delighted if you participate in the reception, you come and you enjoy, we know each other. Then after the reception, we have Professor Zbigniew Lasowski from the Center of Human Trafficking from University of Workers. He would talk about undocumented migrants and as victims of human trafficking. We also have a project manager, Ann Hamat from Finland. She is going to talk about the situation in Finland. And then we have our graduates, our students, and two guests from Brussels, one from Brussels Diplomatic Academy, Vladimir Zerebov, and from the University of Brussels, Shilpi Pandey, and Professor Stefan Smith, who was elected ad hoc judge of the European Court of Human Rights. We have our students, and I didn't mention them. I will mention them at the start of the second session in the afternoon, the names, their dedication, and how well they responded to the invitation. I'm sure that they will provide a lot of insight to our conference. Just not to be too long, I just, after the discussion with Professor Smith, we decided that I will mention a little bit the human rights that matter to migrants. Undocumented migrants, because if they come, for instance, to Italy illegally, they are mainly, or they escape the war, they are undocumented. So I would just want to point out a few things. The question could be, what rights are important for undocumented migrants? What human rights are important? So the cultural disaster tells us or indicates one of the most important human rights, the right to life. And there, because the conference is sponsored by the European Commission, it's the closing conference on of Jean Monnet project. Therefore, I would say right to life. So how well or how better could we protect this right to life? And here we could talk endlessly, and this very well depicted in the papers about the delays in securing migrants. Then we could come to the issue, well, was it because they were migrants, undocumented migrants, illegal migrants coming to Italy? But the issue is that it's not, it's certainly the role of the state, but it's also maybe the role of the European Union to focus more to pay more attention on how the right to life is protected in the European Union. Which this, we can come to something that I have seen with my students very briefly, with my Italian students, very briefly in the class, the Charter of Fundamental Rights that talks about human dignity. In the state of 2000, when Charter was introduced, it was quite innovative issue, the dignity. But the concept of dignity would also relate to undocumented migrants through all the ways of come to the country, the way how they are considered, and so on. Then I would like to mention protection and inhuman and degrading treatment. So what did we hear? There is a new case launched, the case before the Court of Justice of the European Union about secure third countries. So obviously we know, and my students in both classes, they know very well that European right to unlock the problem, the crisis, the migrant crisis through agreements and some sort of understanding with the third countries, the neighboring countries. Here we could mention that, of course, the European Union had interest and also paid every migrant to be taken back and so on. But I think that they did not put enough emphasis on to what extent the country is a secure third country, or maybe the country hasn't been, but is not anymore. So maybe an indication would be to review how we assess which country is a safe country, or frequently question this concept again. And here, for instance, I would refer to Libya, because many migrants, well, they are in detention centers in Libya where many things happens, and they are not protected neither from torture or exploitation in other sense. What else should be protected? Also, recently with my students, we were talking about position of vulnerability. And 2 years ago about vulnerable migrants. So again, here more emphasis and protection, victim of trafficking and others. And I will end because, you know, Martin is waiting with the last thing. But I think in all those rights, the one is fundamental, is right not to be discriminated. And the European Union came with this idea that non-discrimination doesn't matter if you are documented or undocumented, you should not be discriminated against. So here I think that we need to look at some ideas. In the afternoon we will have my students, the Italian group has prepared a presentation on access to health, to vaccines in Pavia's region. Therefore, for instance, we should look at this point to what extent they are treated fairly, and what is the comparison, and why they shouldn't be discriminated in access to education, health, and access to housing and so on. Professor Martin Jones, I know that this is the third time you locked, and because I'm talking and talking and talking, so therefore, but now I have finished. So as I said, Professor Martin Jones is a professor at the University of York. We know each other for many years because We work together at this university, extremely experienced researcher and activist, if I could say, and he would talk about being undocumented. Does it matter for access to justice? So, Professor Martin, yes, your presentation is shared already, so I don't need to do anything. The floor is yours.
Well, thank you, Katarzyna, and thank you for your opening remarks and your warm welcome. And thank you to everybody for attending today, both in person and virtually. My apologies for not being there in person. As some of you know, I was there last week. So I know very concretely what I'm missing, the warm reception, the warm weather, actually. But I'm back in England, unfortunately, this week. And rather than being with you in historic Pavia, I'm surrounded by countryside filled with sheep, sheep that are in the middle of lambing season.
Martin, one second. We can't hear very well. I'm just trying to think if somebody could help with how we could. Maybe I should put it like lower. One second, because you know, just like it's very. Where's Alice? Alice, my microphone. Maybe if I. Yeah. So it's maybe me and not Martin. Okay, so go ahead. Maybe my microphone. Maybe if I switch off my microphone would be better. Yes.
Okay. Well, I mentioned the sheep only to say that they are lambing, and it's significant for our conference because this will be the only 6 months of their lives when they're not marked. The rule here is that they have to be marked within 6 months, tagged and spray painted. And so they'll live the first 6 months of their lives in a unregistered way, which, you know, if you forgive the comparison, although I think the comparison is a point of comparison on purpose, because I think there's a bigger issue about the commodification of migration and more importantly, the commodification of migrants themselves that is embedded in our conversation about the undocumented. And I'll come to that category later in my presentation because I find it one that's not an easy word to get out of my throat. But I guess I also mentioned the sheep to remind ourselves that when we talk about the undocumented, we're talking about practices that are embedded within much larger historical processes. And I was going to tell us by way of opening that we seem to be living in an age of documentation. But in fact, I think actually upon more reflection that we're kind of on the cusp of a new age, perhaps a post-documentation age, and perhaps that's something we can explore in our conversation as well, because we're moving increasingly, I think, from an era when we rely upon pieces of paper very concretely to one where documentation is electronic, to now currently one where it is biometric, where the very indicia of our faces and our fingerprints, our voices, are being used to track and surveil us as part of a bigger surveillance capitalistic enterprise. But really what I want to do by way of opening, and if you'll indulge me, as Katarzyna has by putting me conveniently at the start, is to ask some questions. And so I'll try and not answer any, but rather put some on the table. And I think kind of the moment at the beginning is perhaps the best moment for that kind of intervention. So first I want to say a few words, like I said, about the category of the undocumented. Secondly, a bit more about the rights which are claimed, which Katarzyna touched on. And then finally, thinking through the challenges facing access to justice. And I suppose to answer my question, I mean, I find academic questions, particularly ones that are put in titles like, does being undocumented matter to access to justice? I mean, the answer is usually pretty obvious. And in this case, I think the answer is yes. I think that's fairly obvious. But really, I guess what I'm trying to begin to get us to do is to figure out how. And so I think as much as anything, the questions that I'll be asking will be directed at trying to unpick and explore exactly what's happening in order to prevent individuals who are undocumented from accessing justice in a number of environments. So I guess the first thing I should say is I practiced as a lawyer doing immigration law for a number of years. And I never really used the category of undocumented. I mean, in your legal practice, you're so focused upon the parochial rules of your practice that this kind of broader issue about people being within or outside categories more generally is less of a label that you tend to use. I mean, I suppose in some senses, all of my clients were in various kinds of ways undocumented. I guess I would note, and I think there'll be other presentations reflecting more upon this, that the term that we use to describe this category of individuals has changed over the years, and certainly it changes even today, depending upon your point of view on the legitimacy of some of the claims of individuals in this category to rights. So you see in some of the discourse, individuals without documents being referred to as illegal immigrants, or sometimes just illegals as a proper noun. You see in international law the use of undocumented, but also the idea of irregularity. And I guess that kind of juxtaposes them against the normal, in a sense, the regular. But I find one of the more interesting moves of late is the use of in a way the French language term sans papier, literally without papers. And I say this just to flag that I think sometimes when we pick these categories, we're making not just legal choices in terms of mapping up against the text of particular rules, but also political choices. And one of the things I like about the rise of the category of the sans papier is their deliberate claiming of their predicament. And I'm reminded of a quote from McNiven, who's done work unpacking exactly how the sans-papiers in Paris and or rather in France and in Belgium organize themselves. And she has a quote from one of them about the choice of the term. And she says, the quote goes like this, and if you indulge me, I'll read it to you because it's quite a powerful observation. In France, up till now, our fate as immigrants was either take part in the Republic's process of integration or be deported like cattle. So there we go with the commodification and the sheep again. At the heart of this approach was the notion that we are underground, which has very strong negative charge. A person who is underground is someone who hides, who conceals himself. And if you conceal yourself, it must be because, after all, you have something to hide. We have made ourselves visible, and this is in the form of a protest at a church. We made ourselves visible to say that we are here, to say that we are not in hiding, but we're just human beings. We are here, and we have been here a long time. We've been living and working in this country for many years, and we pay our taxes. In the files of the St. Bernard people, you will find wage slips, income tax declarations, old documents giving leave to stay. There are also passports and visas issued by the consulates of our countries of origin. So the observation here and the closing point that this interviewee makes is that they're not actually undocumented. They have papers. There's documents aplenty in terms of their contribution. And so I think we need to step back a little bit and think about exactly what we're saying when we put people into these types of categories and the politics behind our choice of language. I appreciate that perhaps undocumented slips off the tongue a bit easier, certainly for those of us without much language talent in the sans-papier. But I mean, I think we need to explore exactly how this group is being described. And partly because I think these explanations reveal a bit more about the nature of the category. And this presumption, for example, that it's a binary category, that you're either documented or undocumented, as the quote itself illustrates, these people are documented, just not documented in a particular way that the French state considers important. But more importantly, there's also individuals who may be considered to be documented at one particular moment in time, but are very close to falling into the undocumented category. Think of individuals who are on a visa or have some sort of immigration status that's about to expire, or with an employer where their employment is precarious and that's linked to their status. It's also a fluid category. I mean, people, as the idea of precarity suggests, people become undocumented and potentially people become documented as well. So there is churn both in terms of the people within the category leaving or entering the category, as well as people themselves in their personal situations switching from one side of the line, of the blurry line, to the other side. And I guess the final point I'd make about the category itself is the question of whether it's the documentation per se that is what we're pointing to, or whether it's in some senses the state's predetermination of your lack of status. And here I ask the question, well, what about migrants who have immigration status but can't prove it? What about citizens who can't prove it? I mean, I think it's important for us to remember, certainly in this country, one of the biggest scandals in the immigration area in recent years is the so-called Windrush scandal, where a generation of migrants to the United Kingdom from the Caribbean on a famous ship named the Windrush, epitomized by the famous ship, the Windrush, that came from the Caribbean, bringing them, were over the course of decades told by the Home Office here that they had no status, when in fact they did. And many of them were deported. This is not, perhaps in the scale, it is an unusual event in the United Kingdom, but it's certainly not on an individual level peculiar either for the United Kingdom or any other country. There are accounts of countries deporting their own citizens from most countries that do deportation. They get mixed in and assumptions get made based typically upon a very racialized vision of who the undocumented are, who belongs and who doesn't belong, and then they end up far from the country in which they actually are a national. And then I guess the final point to make about the category is, are all undocumented individuals the same? Are there better types of documents? Are there other levels of undocumentedness? And here, for example, does having a birth certificate in the country, even if that birth certificate doesn't give you immigration status, somehow make you a better category? Does having some sort of document, even from your home country, about your identity, make your situation different? So, I mean, basically what I'm trying to suggest that we need to do over the rest of the day is not to treat the category of undocumented uncritically, to problematize the language that we use in labeling it, but also to problematize the category itself and ask questions about exactly who we're talking about and not presuming that everybody within the category is in the same kind of situation. Now, the title of my presentation, and certainly the title that Katarzyna explained at the conference, tries to link being undocumented with claims to rights. And I'll get to the question of access to justice in a moment, but I want to spend a moment about the problem of rights. And, you know, here, I guess I'm reminded, as we all probably are every now and again, of the famous quote from Hannah Arendt about the right to have rights. And in a sense, the lack of documentation, removing the right to have rights at the very moment when those rights are most often needed the most. But I guess fundamentally, what I think that the question of the undocumented and access to rights raises is questions about the nature of rights and their supposed universality. I mean, political questions about the universality of rights. We see doctrinally that some rights are indeed limited. We see economic rights, for example, in some locations limited in international law. We see other rights, civil and political rights, limited as well in international law. And I draw examples on the slide from the International Covenant on Economic Social Rights, social and cultural rights, with respect to economic rights being limited to nationals in developing countries, and the rights of entry and exit, for example, or rather the rights of entry being limited under the ICCPR, the International Covenant on Civil and Political Rights, as well as the Migrant Workers Convention, one of the core documents protecting all migrant workers and members of their families, having a particular part 4, that applies to migrants who are documented or in a regular situation. So I think one of the things that this question about access to justice by the undocumented, or the sans-papiers, as I prefer to call them, raises is the question to which justice depends upon status. And I think we often deceive ourselves in thinking that the political cause of human rights has manifested itself quite as universally in doctrine as it has perhaps in our politics. But I mean, on this, I guess I would also add, as a caveat to that kind of bemoaning of how much more progress we have to do in the human rights movement, is to say that some rights certainly are extended to everyone, and many rights are. I do work in Egypt with individuals who are undocumented, and also in Southeast Asia. And one of the big challenges in those jurisdictions is convincing the authorities that the right in question actually extends to the individual, because the state in those cases often views the individual primarily as being undocumented. And so the legal challenge is to reframe that individual's identity around, in some cases, being a refugee, but in most cases, falling into some other category, being a child, being a woman, being a worker, yeah, and relying upon both international as well as domestic law that gives rights to a much more universal group of people. And so undoubtedly, many of the conversations that we'll be having today will talk about workplace rights. And here I'm heartened that the work of the ILO has generally been unhindered by questions of nationality, focused instead, as it is, upon workers and workplace rights of all those of individuals who are within the workplace. Now, fundamentally, the question that I ask at the start and that I will close with unpicking is this question about access to justice. And so how does being undocumented interact with claiming rights? For me, a useful framework of analysis of access to justice is the United Nations Development Program's framework for access to justice, which breaks it down into 5 steps and allows us to kind of, in a sense, pinpoint the many problems that being sans-papier might pose for an individual claiming their rights in a jurisdiction. The first is that there needs to be an existence of a legal framework guaranteeing rights. I mean, before rights can be claimed, they need to exist or be recognized to exist. And here we have often out-of-date phrasings in constitutions, as well as in policies that talk too much about citizens when framing rights. And so there's law reform work that still needs to be done. But people need to know about their rights. And often exact rights vary from place to place, certainly entitlements, if not rights, vary from place to place. And so there's a big question about how we make aware individuals, particularly individuals who are new, which by definition many migrants are, to jurisdictions about their rights. There's a need for support in claiming rights, and this is the role of those of us in the legal profession. But beyond that, there's a need for support in terms of facilitating access to justice, facilitating access to the courts, completing paperwork, supporting individuals as they go through processes of claiming. You need a forum willing to adjudicate the claim. And as I said to you a moment ago, in many of the places I work, one of the problems is convincing the state or the officers of the state in the form of labor department officials that the person who's standing in front of them should be understood as a worker and be allowed to submit the paperwork, even if the state initially sees them as being undocumented, as being illegal, and as being unworthy of the activities of that office. And then finally, you need the ability to enforce the decision of the forum, which we often take for granted, but can often be the most difficult problem. In Egypt, one of the first cases that I did with a group of lawyers that I have been working with ever since was to successfully prosecute a government official for violence that they committed against an individual who we could describe as being undocumented. The other steps of the process were actually, in that particular case, relatively easy to overcome, but getting a court judgment to be enforced against a government official was a near impossibility. And so I think we need to think not just about how we help people actually win claims, but how winning those claims can translate into their actual benefits, the benefits of the judgment, how those judgments can be put into effect. So I hope with those comments, with those questions, I've lived up to my promise to introduce the topic, to not give you any answers, but simply to ask questions. And so thank you for your indulgence. I look forward to popping in and out of the conference virtually as we progress in our conversation. And as I said at the start, my only regret is that I couldn't be with you in person today.
Professor Jones, I really thank you for this for your insight into undocumented migrants, the vision, how does it matter, where there is a distinction. I think it was perfectly within the scope of this conference and so well focused. So I'm really, really grateful. And I think that it was just introductory speech that we needed. Now I open the floor for questions. So you couldn't hear what I said, Martin?
I can hear you. Yes, I heard what you said.
All right, you're right, because I just switched off because at the moment it was an echo when you were talking, so it was better. So any questions from the audience? But it was just come forward with something. Yes. Well, you have to, can you come here, or at least let me see. They gave me this tool. Let me see if I can, yes. So, but if you are here, come here so he can see you. Okay.
Hi, actually, thank you so much. My question will be fresh, but I was wondering, when we talk about the commodifying of, in your work, undocumented migrants, I work on like decolonization of Muslim women's rights discourse, and I think the commodification of Muslim women continues to be like, it's a continuity, like, you know, everywhere, every society. I'm not just talking about France. I'm taking examples from East and West. Like, I think in India, they do the same. I think in France, they do the same. Everywhere, migrant or minority women, specifically Muslim women, continue to be commodified. I was just wondering, do you agree with that kind of observation, or would you like to still suggest that it's mostly concerning undocumented migrants? I just thought I'll pick your brains because I wouldn't get a chance again. So, you know, sorry, I just took the opportunity.
Yeah, no, absolutely. Thank you so much for the question. I would agree with you. And so I don't think commodification is a singular phenomena that applies, I mean, even particularly to migrant workers. It's one that, as you point out, has been observed in a number of different contexts. Yeah. I think the bigger challenge for us is to make sure that we embed our conversations about being undocumented within our bigger concerns, whether it is about decolonizing knowledge and immigration processes, whether it's about gender issues. I mean, you know, we can't simply, I think you're absolutely right to point out that there is such a obvious overlap between what's happening to migrants and what's happening to other groups of individuals, right? Yeah. And we need to link our struggle on behalf of the undocumented with those other struggles. And I'm reminded, I think, of Andrew Lurd's comment about there's no hierarchies of oppression, you know, that there is just oppression. And so the oppression of migrants takes nothing away from the oppression of women. Other than to say, though, I suppose, that within the category of undocumented, obviously there's other dynamics going on as well, right? So to use your example, Muslim migrant women will obviously face particular challenges that will be different than non-Muslim migrants, and for that matter, non-Muslim men migrants.
Yeah, exactly.
So yeah, I would agree with your comment, and I would definitely not try and separate out the undocumented as some singular example of commodification. Yeah.
Thank you so much. Sorry, I just took the opportunity to ask you. Thank you.
Thank you so much, Martin. So because we need to stick with the time. So it was so interesting. But if you have time, you tell me. You see, you know, in the end of the day, we have closing debate at 5:30 Pavia's time, which is not the UK time. If you manage,
yep, I'll pop back. Absolutely. Thank you so much.
Thank you so much, Professor. I think it's Professor Nat that is going again as a perfect focus of undocumented migrants and the right to defend human rights. I think that she's going to say everything what I just summarized in one, don't you think? In 1 second, what human rights matter. So I think it's off. I hear you speaking very much. So no, you have the slides on this computer. You have somewhere on this computer, but you have to go to desktop. Well, how am I going to do desktop? Yeah. Just only don't switch anything. And somewhere you have your slides. Can we?
Yeah.
We have it?
Yes.
So, okay.
Okay, so thank you. This is not the correct one.
You send me the wrong one.
Is that the one that you downloaded?
Yes,
Can I download
this is
it?
the last one you sent it. This was not the right one?
No. Okay,
What you sent me?
just give me a second. Just give me a second.
It's only don't, because we don't need the issue.
Okay, so thank you, everyone. Sorry about that. Right, so it's a pleasure to be here with you. I've really enjoyed the time visiting in Pavia. It's such a beautiful location and we're in such a beautiful space right now. So what I'm talking about today is really a project that I worked on with UN Women. I shared this with the class that I taught yesterday. So apologize for those of you who are in my class, you're hearing some of the same feedback. But it's really trying to think of how undocumented migrants, people who are in an irregular situation, can be part of the global movement of protecting and promoting human rights. And to start us off, I wanted to recall with all of you, what the UN Declaration on Human Rights Defenders states, yeah? So in 1998, the General Assembly, the Declaration on Human Rights Defenders, the real name is actually longer, but it's abbreviated as such, and recalls that everyone has the right, individually and in association with others, to promote and to strive for the protection and realization of human rights and fundamental freedoms at the national and international level. And these rights are expressed in the declaration, but as the UN OHCHR points out, these rights are codified in international human rights treaties. So you see them referred to in the ICCPR, in the ICESCR, and other human rights treaties. What the right to promote and protect human rights, the right to promote and protect human rights is a right that all of us have. Sometimes the UN refers to, people who promote and protect human rights as human rights defenders. And that's actually a term that is commonly used by the UN, but not necessarily amongst human rights communities or people who are doing human rights work. So there's a common misperception that they are activists or they're NGO staff, and a lot of people don't see themselves as people involved in human rights. But actually, if you look at the actions, they could be journalists or trade unionists, doctors, teachers, even the police, parliamentarians, government officials, yeah? People who are part of the state apparatus as well as not. As long as you are engaged in the action of promoting and protecting human rights, you are considered a human rights defender. But unfortunately, we know that people are threatened and attacked for this work. And the main aim is really to intimidate, to repress, and to silence people who are, often challenging power, often, calling for injustices to be addressed. And these range from threats and accusations, both online and offline, to physical harm, kidnapping, torture, disappearances, surveillance. Stigmatization is very common. So calling people terrorists or enemies of the state, calling women prostitutes or loose women, it's very gendered, stigmatization. And then criminalizing activists for either alleged crimes or using very restrictive laws that are disproportionate to their actions. And then using digital means to control access to information and also jeopardizing their devices and their records and their data. What is of particular concern nowadays, especially in the context of Europe, but also in other countries and contexts is the criminalization of solidarity, where states are legitimizing the criminalization of solidarity through narratives that construct migrants as threats to security, and citizens need protection from them. And so those who help migrants, such as lifeguards or journalists or volunteers, ordinary people like you and me, who are facilitating or helping migrants in any way, even on humanitarian grounds, have been charged with offenses related to facilitating irregular migration and people smuggling. And Martin and I have been working on a project in Indonesia that looks at how fishermen have been rescuing Rohingya refugees at sea, but then being criminalized for that, being accused of smuggling and participating in irregular migration. So the project with UN Women was a really interesting one. It was a response by UN Women to look at how women in particular and gender diverse migrants and activists are being targeted for supporting and helping migrants. And they convened a series of dialogues and conversations with independent experts, as well as with women and gender diverse migrants and activists who are participating in helping secure migrants' rights. And out of these conversations, we identified two main areas where states need to act to secure the right of people to protect and promote human rights, especially undocumented migrants. And from these reflections, we realized that when the rights of migrants are not secured, it becomes harder for them to defend rights. And I explain a bit more. So the first set of recommendations are really that states need to create an enabling environment for the defense of human rights in migration contexts. So to recognize the relevance and application of the Declaration on Human Rights Defenders, and to ensure that they implement the measures, legislative, policy, and administrative, to ensure that people are able to defend human rights without being threatened or attacked. We call on states to counter the stigmatization and criminalization of activists, including by publicly recognizing the importance of their work. We call on states to ensure that everyone, in particular those supporting migrants, have access to justice and effective remedy, including ways of reporting human rights violations. Now, in the context of undocumented migrants, this becomes even more significant because, as we know, a lot of people who are in an irregular situation feel very nervous or scared about coming to the police or coming to the authorities to report crimes. And they're worried that in doing so, in presenting themselves to the authorities, they will endanger themselves because they are worried about being arrested. So this brings us to Joseph Karen's argument about the importance of firewall protections. And Joseph Karen talks about the importance of separating the immigration status of a person from the crimes that are being addressed or the human rights violations, and says that a person should not be, the immigration status of a person should not matter when we're protecting human rights. Otherwise, people who are undocumented will never have their rights protected. They will always just be very fearful of reporting or fearful of seeking justice. We call on states to develop effective protection measures for those who are facing threats and attacks that are flexible and timely and sensitive to their specific circumstances. And also we call for states to recognize that, defending human rights is a positive thing for society. It should not be criminalized. It should not be seen as a negative thing, but it's something that helps to secure people and societies and becomes a positive change in society. The second area really focuses of recommendations really focuses on the importance of the rights of migrants themselves. So as I was saying earlier, when you can secure the rights of migrants, then it enables them to stand up for their own rights and to defend the rights of others. One of the calls we have for states is actually to increase the number of legal avenues for movement, yeah? Rather than forcing people to travel through irregular routes, to actually create more options for safe, orderly, and regular migration. To end violence and harassment against migrants, yeah? To take strong measures to end forced labor and trafficking, ensuring that the laws, policies, and practices around them are gender sensitive and survivor-centered and rights-based. And to treat those who have suffered from forced labor and trafficking with in humane ways without re-victimizing them and punishing them, which sometimes happens when their status is not recognized. To protect their rights when they are deprived of their liberty, especially refraining from detaining children and implementing alternatives when that's possible, as much as possible. To ensure that migrants, including undocumented migrants, are able to engage in decent work and to protect their labor rights irrespective of their migration status. So this is in line with the ILO's calls for all labor rights to be protected no matter the status of a person in the country. To ensure that migrants have access to services in a non-discriminatory and gender-responsive way, again with strict firewall protections in place. Otherwise, people will not seek health care. They will not, put themselves forward for and ask for help if they're worried that they will be arrested because of their immigration status. And I think this point will link to the presentation later on access to healthcare for undocumented migrants. And to ensure that nationality laws enable gender equality, because sometimes people also are placed in very precarious situations when nationalities laws discriminate against them. So I think really just the final point is that it's important for migrants themselves to be part of defending rights, whether or not they are documented or undocumented in an irregular situation or an irregular situation or a regularized situation. It is often the case that a lot of human rights violations that occur during migration are seen and witnessed by migrants themselves, yeah, because they are in those journeys, they're in those precarious situations. So it's important that they have access to ways of reporting and dealing with the crimes or the violations that happen, because they are also often the ones who are trusted by fellow migrants who are in distress. But we know that it's often more difficult and dangerous for them to do so because of their concerns about being arrested, their concerns about jeopardizing themselves, even as they promote and protect the rights of others. So, just coming back to this idea of the firewall protection, as Joseph Cairns says, it's really important that all states have applied the legal principle that no information gathered by those responsible for protecting and realizing basic human rights can be used for immigration enforcement purposes. Okay, I look forward to discussing these ideas with you further. Thank you.
I just wanted also to clap for Martin. He probably is not on, but because he was, we didn't clap, and it was important as well. So this was extremely interesting, and Professor Knapp really flagged up a few points like stigmatization, like all sorts of discrimination and importance to favoring or at least facilitating access for defenders of human rights and to defend those people. So this is a very important contribution to this conference, and I ask maybe one question. be fun for those who are coming from, yes. Yes, Elnas, come here, or you can use this little device. I don't know if this was off. This was off or not? It doesn't have any.
Yeah.
Because if you want firstly they need education for the regulation.
That's a really good point. And this comes to the crux of the problem, you know. The problem is when states see or state authorities treat people as if they have no rights. And that's not correct according to human rights. Because human rights doesn't say, if you are a citizen, you have rights. If you have a passport, you have rights. If you have, you know, it says no, all human beings have rights. Whether you have a paper to prove your identity or not, we should all have rights, no? So I think the problem is introduced when we say only certain people in certain circumstances with the right documents, you know, are bearers of rights. And that's something we definitely have to always push back against, you know. But a lot of systems tend to be set up that way. And that creates a lot of violations against undocumented migrants in irregular situations. You have employers committing forced labor, committing, you know, labor exploitation. And where do they go? Because when they go to the police say, well, yeah, you're undocumented, I don't want to help you. You know, you're not my problem. And that is a human rights violation, you know. So you've identified exactly the problem we have, which is they're seen as people without any rights or treated as such by those who are supposed to protect.
Any other question, maybe?
Yeah.
Yes.
No?
I hope to be able. So I can,
No, it's not working.
So come here.
you said, have a theater voice.
I don't know. You know, on YouTube, if you ask the question there, so that's important. Yeah, excellent.
Thank you. The defenders of rights, not migrants, because on a high level of explanation, let's say that in the East, we can be the man to decide and to give like for rights or laws in the society, but they have not been able to now. And with the process of modernization, we are seeing that giving rights, giving more power to women, they have been able to create a more equal society. And also, I think that can be changed as the feminism. Okay. Secondly, I would say that how migrants must defend themselves. Maybe institutions have a budget, we have like the rights of migrants. Not
No, I completely agree with you on those 2 points. I think that the reason why these recommendations focus on women, but I expanded it more broadly, is because often in the past, women who defend human rights face risks that men don't face. you know, and that often has to do with patriarchal norms about ideas of the place of women. So in conservative patriarchal societies, for example, women say, oh, you know, if I protest in the streets, I'm seen as in a bad way, you know, I'm seen as loose, immoral, not looking after the family, bringing shame to the family, you know, and a lot of norms around who a woman is and what a good woman should be. They are often, if they speak up, then patriarchal ideas sort of keep them down and keep them silent. So these recommendations were using an intersectional approach to say, we need to look at how gender norms and expectations affect women as activists, as defenders of rights, but also how migration status affects, you know, the status of those who are defending human rights. So migrants are often, especially if they're undocumented or in an irregular situation, systematically shut out from institutions that protect their rights, shut out from government services, shut out from, you know, places where they need to have access in order to secure their rights. So I agree with that. Thank you very much.
Thank you, George. So shall we leave the questions, any very urgent question? If there is no urgent question, so Alice will stay with us this afternoon.
Yes.
Thank you very much. Thank you very much. But as I said, we were clapping, but we should also now, so important, you know, just it's so important to tackle things at the local level. So, Dr. Vanella, you are really a treasure for us, you know, with your information, insight, and consideration of the topic. So, Dr. Vanella, advisor and founder of Coordination Refugee Welcome Italy, but in Pavia. This is what he mentioned, and he told me, and he is going to talk about extremely important issue about the Cutro law that is the very, very recent law on special protection, or rather of lack of the special protection or removing the special protection in Italy. So I said that we could expect a positive response of politicians and the government to the Cutro disaster. Instead, we have something completely different. So we have two talks about this, but different focus, obviously. So it's very important to flag up this concept. Dr. Vanella, thank you very much.
Thank you very much, Professor Gromek, and very thanks to give me this opportunity to talk about this very delicate argument. Hello, everyone. My name is Luigi Vannella, and I have been dealing with immigrant rights for about 15 years. I am a legal advisor in 5 reception centers. Since 2020, I have been the founder and coordinator of the Pavia office of Refugees Welcome Italia, which deals with the reception of refugees with Italian families. Today, I will tell you about the Cutro decree, converted into law and entered into force a few days ago, May 6th. The decree still has some points to be clarified, and as often happens, we are still waiting for clarification regarding the interpretation of and the application of some revisions. What I am about to describe is a very difficult landscape. In the fold of this decree, we can see the will to give a tough answer to what in Italy is perceived by many as one of the major social problems: immigration. The government's policy has been to shift the entire center of gravity of immigration discipline to work rewarding those who have it and punishing those who, without fault, cannot find or lose it. So, at first, I would like to spend a few words on the decree's name. Why Cutro decree? Cutro is a seaside resort located in Calabria, in the south of Italy. On February the 25th, 2023, a ship with over 180 migrants on board sank near the coast. For unclear reason, political, bureaucratic, technical, we don't know, the relief system did not work. 91 people died at sea that night, and 31 children. And I can add 4 children, they had more than 14 years. But in my opinion, children anyway. So why give a decree the name of a massacre? That's the question at first. Before talking about the changes introduced by the Cutro decree, it is necessary to take a few steps back and see how humanitarian protection has been regulated in the last 25 years. The first version of humanitarian protection was a residual form of protection for those not entitled to international protection. It was granted for serious reasons, in particular of a humanitarian nature or resulting from a constitutional or international obligation of the Italian state. It is based on 3 assumptions: serious humanitarian reasons, constitutional obligation, international obligation. From 218, we will no longer hear express mention of humanitarian protection, and in the regulatory language, its place will be taken by the word special, but very fluctuating contents. The Salvini protection was granted exclusively in compliance with the constitutional or international obligation of the Italian state. So there is no longer any trace of the serious reasons of humanitarian nature. After 20 years, therefore, humanitarian protection, as we knew it, is repealed and survives only in a residual form. Sorry. Second version of the special protection was certainly one that best protected the rights of migrants. Though the law was passed in 2020, and we call it La Morgese Decree. In any case, expulsion or refoulement to countries where the foreigner can be persecuted or tortured was not permitted. And the article is the Article 19 of Legislative Decree 286, 1998, Consolidated Immigration Text. It is the biggest immigration law in Italy. However, the scope of protection was wider than that of political asylum, race, religion, nationality, membership of a specific social group, or political opinion. Indeed, it includes gender, sexual orientation, gender identity, language, citizenship, personal or social conditions. So we need to remember this last element because we will find it soon. The residence permit for special protection could be converted for work reason. Special protection could be granted by territorial commission, but it could also be requested directly from the police headquarters. And now, here we are at the last chapter for now of special protection. Also in this case, expulsion or refoulement to countries where the foreigner can be persecuted or tortured is not permitted. And it's the same article we already read. This protection is granted in compliance with the constitutional or international obligations of the Italian states. Migrants can no longer ask for it at the police station. It can only be granted by territorial commissions for asylum seekers or in court, because you know there are two ways to get the international protection. It cannot be converted into a residence permit for work reason, and that's a very big problem, because you can imagine that if you have a residence permit and you don't find a job, you are immediately illegal. So we will see what happens. Those already issued will be renewable only once and for only 1 year, but will remain convertible. Private and family life, social inclusion, and integration are no longer considered. This point is very important because you need to imagine that in the reception centers, our goal, I work there, so I know how it works. The goal is the integration. So why work on integration in a world where integration is not considered anymore? That's the point. Additional amendments. In the Article 19, we can read a foreigner who is in serious health condition cannot be expelled. We are talking about serious psychophysical conditions or serious pathologies. A residence permit for 1 year for medical treatment is issued, renewable as long as the illness lasts, and convertible. With the modification of Article 19, the concession for serious psychophysical conditions is excluded. So we don't have any more some kind of defense in these cases. Asylum seekers are excluded from the integration reception centers systems, which will be reserved only for those who have already obtained refugees status. It's another big problem, because in the integration reception system, we have the resources to make integration. And if integration is reserved only for people that already has a protection, it doesn't have sense again. Now we will talk about the CPR, staying centers for repatriation. They are places of administrative detention intended for irregular migrants. Here, people who have not committed crimes serve the hardest sentence, one that deprives them from freedom. Activist networks, such as No CPR, Stop the Lager, denounce the inhumane conditions in which those subjects are forced to live. The new decree intends to establish a CPR in each region, raising the number from 10 to 20. In this moment, they are formally 10, but they are 9 actually, because the one in Turin was burned by migrants because of the very hard condition where they live. So the only way to be visible outside is to do something extreme. So they burn everything, and now that place is not a CPR anymore in this moment. The decree extends the timeline of administrative detention, which can be up to 12 months. But we know that, in fact, it lasts even longer, leading people to suffer physical and mental damage, even to suicide. We had a lot of suicide in Italy for this kind of administrative detention. I would like to make some final consideration. The number of irregular people in this way will increase. These people will be excluded from one day to another from any public service and protection. This will generate invisibility, access to illegal work, blackmail, and exploitation. The number of people kept in the CPR forced into inhumane living conditions will increase. The number of deaths will increase due to the absence of safe channels and humanitarian corridors. Thank you very much.
So thank you very much. I said already that our Luigi is really a treasure. He can provide some insight from outside of academia, and this is a very important issue to liaise a little bit theoretical with practical issue and to flag up the real problems that happen in the centers and so on. So and also the subject matter is extremely important. So it's very important that we discuss the need, what sort of protection, and in this time, well, I think that there are other ways to manage migration rather than remove the basic human rights guarantee. We thank Luigi very much. Any questions? Yes, Shamir, take this because on the YouTube, Alice is going on the YouTube because it's disappearing from time to time, so I don't know what. Yeah, Shamir, yeah.
Yes, it's not a refugee camp. What is it? No, I explained the difference. Okay. Okay, in Italy we have hubs where migrants are put in when they arrive in Italy by coast, by the ground. Okay, and from these hubs they are put in different places. We have Casa. The translation in English is extraordinary reception center. Or we have SAI, I think the best system because it's the most organized, and it's the second level of reception. But the CPR are just a place to put people waiting to send them home. Well, that's the good question, because normally for long they could be there from at least 180 days. And this period can be longer for some reason that we don't say here, because there are many technical aspects. At first we need to say that only a little part of all these people in the CPR really go back home, because Italy don't have the instruments to send back all these people. We don't have all these planes. We don't have all these boats. And so people stay there for months, maybe years. But the worst thing is that they don't know how much they will stay there. If I am a criminal, I know exactly when I will go in prison, and I know exactly when I will go out of the prison. They don't know, and they didn't make any crime. That's the very big problem. And the condition of these places are awful. They have no right. Even in the prisons, you can somewhere, you can call someone, you can call home, you can receive people. These places are very close. As refugees welcome coordinator, I invited this association. I want to say No CPR Stop Ilaga in Pavia, and they explained that they were able to enter one of these places only with parlamentari in inglese. Parliament. So, but also in that case was not easy, because they need to wait a lot and ask for permission to prefecture, and so it's a very big.
Only politicians.
Only politicians can enter, but sometimes you can ask to make a visit there, but just theoretically, because in reality they don't permit it. Sorry, I can't hear you.
What I'm trying to say, anyway, people are getting repatriated to the country. So why do they have to go through this CPN? You can just send them back right away. Why more punishment?
So you're asking why are they put there?
Yes.
And not immediately in their country? Because we don't have the instruments. Because an airplane costs money, and they wait to organize, and somewhere an airplane goes in this place. Well, consider.
Can I just say one
Yeah.
thing? Maybe 3 years ago or 2 years ago, I don't remember. In my Italian class, we had a presentation on the process on the basis of the return directive. So how does it happen? I don't know, maybe Shamir was in the class. So how much does it cost to send somebody back? So as I said, I'm not probably perfectly updated because they found out that it was 7,800 euros, but it was probably 3 years ago. It cost to send a person back. Why? Because first the person needs to be detained, then it needs to be, you need some guards to bring the person to the airport, some assistance. So all these assistance plus airplane and so on, it was to return somebody to the country of origin or the safe third country, European safe third country. We discussed this in class. Well, this was almost 8,000 euros. I said 2 or 3 years ago. So I think if I could complement what Luigi said.
Thank you very much.
Yeah.
To ask a very quick question. Generally, in a degree, have some products with fundamental human rights for is it possible that someone go through the court and ask for this domestic law or not? For example, having for compatible with the fundamental standards of European Union.
The answer is yes, and there are a lot of people that try to get a lawyer, but in that place it's very difficult to make a phone call. So how to look for a lawyer when you don't know the language, you have no contact, you have no right, you have anything. So the mission of these networks is also the one to reach these people and to talk with these people, to give assistance. Thank you.
Thank you so much. So thank you, Luigi. We just you stay with us all day, I hope. Excellent.
Yeah.
And with Roberto provides also some very interesting remarks, I see. So Professor Galzotto, that always assists us international conferences. So thank you so much, Luigi, for everything. Thank you. It was really good. Professor Galzotto, the floor is yours. So this would be in connection what Luigi has done. Here. Just pay attention not to detach anything because I'm so bad in. One second. Maybe the problem is the like Alice problem. Let me. I can do like this. I can detach this, which is mine. Put it here. Okay. Then we stick to this one. You have to. Yes. I think that the European Union should standardize this as well, because I have the same problem. And the hall is too big or too small, or is it okay?
It's okay.
Yes. And it doesn't fit and something. So thank you so much. And but again, the screen disappears. It worries me. Somebody has an idea. Shall I call for the technician? Alice is going on the YouTube, right? Although.
It's just for seconds.
Yeah.
Thanks to Professor Gromek for this invitation, and thanks. He going deep in the legal aspects of the Cutro decree. To me, to say more concentrated on the discursive part. When Katarzyna asked me to intervene in this conference, I thought I could contribute by bringing a reflection and right to protection from a sociological perspective, from my discipline, yeah, sociologist. In this perspective, I would like to suggest two irregularity and right to protection, not only as a legal condition defined national normative framework, but also as part and result of migration policy. Adopting this point of view, we will see that the criteria by which migrants are defined as irregular rather than asylum seekers or refugees change as migration with profound and long-lasting effects on the destiny of those who fall into one or in the other categories. The history of the arrival of migrants by sea in Italy, on which my contribution focuses, presents many examples in this sense. Starting from the 90s up to the last few days, in which the Cutro decree was converted over 5 million. This is the graphic representation of arrival by sea on the Italian coast from 1998 to today. Why 1998? Because it's the first year for which data are available for all the Italian coasts. But already in 1991, over 45 people arrived from Albania on the coast of the Puglia region. This phenomenon, the phenomenon of arrival by sea, also that occurred continuously for over 30 years, continue to be represented and managed as an emergency. Again, within the public discourse, it is mainly associated with the entry of irregular migrants into the country. This happens even if it's true that these entries come in. It's very equally true that in many cases they concern the potential asylum seeker. In fact, coming back to the graphic representation, in fact, peaks of our strong instability, conflicts, and humanitarian crisis in the context of origin. In 1999, for example, the war in Kosovo. In 2008, for example, with the humanitarian crisis in the Horn of Africa. In 2011, this peak of arrival coincided with the so-called Arab Spring in the MENA region. And again, in 2013 and 14, for example, many people reach Italian coast fleeing the Syria conflict. And another important data is that in this year we also registered peak in asylum requests in our country. To this picture, we have to add the provenance of many migrants from countries where, even if they are considered safe countries, Human rights are systematically violated. And we have to add the fact that in many transit countries, like for example Libya, the difficult living condition as to require some form of protection upon the arrival in Europe. So, who are the people who arrived by sea in Italy? What rights do they have and what rights are recognized to them? They are irregular migrants. They are clandestine, to use the Italian word, or they are potential asylum seekers, people who have right to be protected. The answer today, as it has been over the last 30 years, are according to the reading and the representation time to time of arrival by sea. Representation, this one, that tend to simplify reality and from which individual paths hardly emerge. So there is some kind of generalization of people arriving by sea, subjectivities, personal paths, the reason of the journey don't emerge. Specifically, the use of an emergency phrase that arrival by sea as a sudden and contingent phenomenon as other instrumental recourse, especially instrumental in terms of consensus, now to the humanitarian element, now to the securitarian one, basing the policies and the rules of the governance of law on one or so the frame of emergency are this continual shift from the humanitarian to the securitarian elements, following, let's say, the need of consensus of that movement. As I told you before, the history of arrival by sea in Italy is full of interesting in this. The first one, the first emblematic case is that, in my opinion, of 2011, in response to the arrival Arab Springs. In the first months of the so-called Arab Springs, so from January to March, about 23,000 Tunisian citizens arrived in Italy. The Italian government denied by Europe the existence of humanitarian emergency invoked to request the application of the Directive 55 of 2001, the directive that has been applied for the first time in response to the Ukrainian the Tunisian citizen a temporary permit which allowed them to legally disperse in Europe. So what happened? Italy calls for and this was instrumental to give Tunisian permit not to stay, but to go where they really want to go, the rest of Europe. Europe said, no, there is any humanitarian emergency. And so what Italian did? Apply this internal law to gave to Tunisian citizens this temporary permit that allowed them to spread and disappear in the rest of Europe. This made the crisis, let's say, invisible, and gave to Italian citizens the idea that the government solved the crisis. In the same time, on 4 April 2011, Italy signed a new agreement with the Tunisian new government, and starting of April, every Tunisian citizen who reach Italy by sea has been identified and pushed back as irregular. So you can see how in a few hours change the definition of the same people arriving from the same place and having the same. In the same year, after April, Italy was interested by the arrival of people fleeing Libya after the fall of Gaddafi. In that case, the government, for the same reason of the need to ask for the recognition of a humanitarian crisis, decided to introduce this person in the humanitarian channel. So let's say the Italian government pushed them to ask for protection. There was a 237% increase in asylum requests that year in Italy. But where was the problem? These requests came from people who had been in Libya for years as workers and who were therefore not granted international protection, generating a short circuit that was solved only after 2 years with a sort of amnesty law giving humanitarian protection to those people. Humanitarian protection that, as Luigi said, has been abolished in 2019. So this is the first relevant example on how narratives, representation change the way in which normative framework is applied. The second example is related to two important shipwreck in front of the Lampedusa island in 2013. These two shipwrecks 13, just. These two shipwrecks caused over 500 deaths and shocked, at least apparently, the Italian and the European public opinion and institution. Those on 18 October, 2 weeks after, a military and humanitarian operation called Mare Nostrum was launched by Italy with the main objective of carrying out search and rescue activities. So it was a humanitarian, military and humanitarian operation, but mainly humanitarian. The aim of this operation was search and rescue, not patrolling Italian and European coast. The people rescued by the ships during this operation were welcomed in Italy, in most cases, as asylum seekers, in a way that we could say, again, almost automatic, as happened in 2011 for people in Libya. An important scholar studying refugees in Italy, Chiara Marchetti, wrote a paper referring to that operation that was done
refugee to underline as this operation as mailing an humanitarian dimension. I put here some images of that period, and was of course the first one is the one who impact more on our emotion, and is a symbol of the tragedy. But I also want to put this front of the flowers. This put in the sea by Pope Francesco, that chose Lampedusa as his first visit outside the Vatican. This picture, in my opinion, underlines this humanitarian narrative that prevail in that period. But unfortunately, for a short period. And recent example is what happened in Cutro. In February 2023, one of the many shipwrecks that followed those of 2013, and the closure of the operation Mare Nostrum 1 year later, once again received great attention for having occurred a few hundred meters depth of Steccato di Cutro in Calabria. We know that many thousands of people died in the last 10 years trying to reach Italian and European coast. But it seems that this impact on our perception only when it happens immediately on the other coast. When we see the bodies of the victims as poured in Lampedusa, and in this occasion in Steccato di Cutro. What we expect after this new tragedy? We expect maybe a new Mare Nostrum operation, but many changes, many things have changed in these times. And one is the orientation of the government that is now strongly anti-immigration. And so what happened? This government decided to use the name of, so Luigi already underlined, use the name of Cutro for a law that criminalized migration and reduce protection, abolishing the special protection, and so making possible of to find protection for those people needing protection, but in a condition to not have the recognition of an international protection. That it was exactly what humanitarian protection before and special protection after did. This extremely concise review want to suggest that when talk about undocumented migration and better protection, the regulatory framework that determines these conditions is certainly relevant, but it is equally fundamental to understand which representations, discourses, and policies this regulatory framework reflects. And this is important because it is what we as scholars, activists, operators, and citizens can act on. For this, I would like to conclude with another example, an appeal for a better protection launched by an important Italian NGO, the CHAC,